We are going in the right order. You put the lawyer last. When you create a lot of problems in the business, the regulator is at your door, you've lost money, somebody is trying to pull out from the contract, and you are facing adversary, an absolutely adversarial position. So that is where my role comes in. You can also thank me that I'm not going to put you through a presentation, because I know if the bar gets opened while I speak, there's nobody going to be there in the room. So I'm going to talk to you. I also want to thank all of you, because I made it a point to attend all the sessions right from the beginning, because this is where I get to learn. Otherwise, I'm in before courts or with clients and in law books. But listening to AI, all the probabilities that can happen in businesses, in a nutshell, has been a very, very enriching experience. So thank you very much for that. I'm going to set the context of privacy in general before I actually dive into DPDPA Act, because most of the times, especially when people are from a business background, you're looking at DPDPA Act as a compliance mechanism. And the moment you look at it as a compliance mechanism, it is something that is getting thrust upon you. So this is something that you don't want. So that is why I said we come in the last. Compliance is something that needs to be wished away. It is not something that really comes from within, and that is why it is a task. It is something that creates a burden, and this is not really a welcome move in any of the businesses. So I want to set the context, because then it becomes easy to understand why privacy, because most of the panelists did speak about what data privacy is, but really, does it translate into action is a question that we need to ask ourselves, and that is where the regulations come in. We always say that, so ethics, and so I think in one of the panels it was also discussed about the ethics and business ethics that come in. We always say that ethics don't come naturally to human beings. You know, we are better behaved when we are watched. And that is where the regulation comes in. We want to believe we all are very ethical. We want to believe that we are all good people. But the moment there is no regulation, businesses have done what they want to, and that is why all the countries have been scrambling for data protection legislation. If we all had looked at personal data from a very ethical angle, there was no need for regulation, there was no need for regulators, there was no need for such hefty fines that have been imposed across the world. So it doesn't happen naturally, let's accept that. The moment the sun goes away, because these are also called as sunshine laws, the moment the sun goes away, we are ready to do what we want with other people's data, especially in the Indian context. So when I talk of privacy as a concept, why did Europe have privacy legislations which were safe harbor guidelines right from 95? And then came the Privacy Shield, and then came GDPR, because Europeans as people were very, very careful and very touchy about their personal information. And therefore, it came very naturally to Europeans to have a data protection legislation. It was a very wide umbrella legislation that they had many, many years ago. At that time, we didn't even know what privacy meant in the real context. US had their own type of sectoral laws which governed every sector, health, finance. So you had the SOX, you had the HIPAA, now you have the CCPA, which is basically a consumer protection data privacy mechanism. And India did a catch-up game. Why? Because we, as people, are not really concerned about our personal information or our private information. Now, which were the companies who were getting into compliance all these years? Those who were forced to comply with GDPR. So again, that did not come naturally, because our counterparts wanted us to comply, we complied. And said, oh, there's a cost to it, and we need to do this because it's GDPR, etc. Now, having said this, privacy actually is not a very alien concept for Indians. Privacy has been very deeply enshrined in what is called as a very fundamental right, which is the right to life. And earlier, we also said that this is the basis of any democracy. Now, why do we say this? Because when you say right to privacy as a person, it meant right to live your life protected from government interference. That was the right to privacy which was meant earlier, and then I'll come to the Puttaswamy judgment. The government cannot interfere with your decisions, with what you do, which religion you follow, your thought processes, and all your communications should have been protected as private. And what you do in your private life should remain private. And I'll give you an example of this. Even it was applied to convicts. So let's say somebody has been accused of an offense, but he's out on bail. So typically bail orders will read as that every second Saturday he needs to go to the nearest police, he or she needs to go to the nearest police station and give that person's attendance. What did the police start doing? Just so that the convict doesn't abscond or the alleged offender doesn't abscond territorial jurisdiction, the police started keeping a tab on his cell phone, tower locations. And a case was filed by the offender saying that this is against my right to privacy, because what did the order say? Go to the police station and give your attendance. All other surveillance is against my right to privacy. And there was a landmark judgment which came in that it said that you are going beyond what your powers are as police authorities, and that system sort of was squashed down. And there were several other such cases that came in. Eventually, all of this got together in the Puttaswamy judgment, which I'm sure most of you have heard of, which was a 9-bench judgment, which said that right to privacy is intrinsic and is a fundamental right, though was already there in your right to life, now has been called out as a separate right to privacy. And data privacy is one small subset. We also need to understand privacy in the larger context, because then it comes naturally. If you keep on saying data privacy, it seems a little trivial, you know. But actually, how you deal with personal data is the bedrock of democracy, and we all saw that in Cambridge Analytica case. That actually your mind can be manipulated by the data you put out in public, so that your basic right to choice to even appoint a government of your choice is manipulated. That was what it taught us, that what can data do to you? It can make you elect a government that you don't even want, because your mind has been manipulated and you don't even know that. And that is why the constitutional law has established right to privacy as a separate right, which says that no government organization could have done that. Because we all believed it was only the governments who interfered with our lives and with our data. But I think businesses are doing far greater harm than what governments are doing. Because the quantum of data businesses have and use and generate and misuse is far more than what the governments were doing all this time. And that is why this very robust, very prescriptive legislations have come in, which want to safeguard us as individuals. So now you have to wear a different hat. If you wear a business hat, it's very difficult to understand all this. But if you wear a person or as an individual, it becomes very easy to understand, because then it's common sense. It's my data. What is really, if I have to give you a very basic rudimentary definition of privacy, it is my right to ask a question to you as a business, what are you doing with my data? That's all. This entire legislation can be summed up in this one sentence, that I have a right as an individual, because it is my data, what are you doing with it? How are you taking it? Where are you storing it? How are you using it? When are you deleting it? And do I have a right to see it at any point of time, and do I have a right to amend it? As simple, right? I mean, why do I even need to talk of DPDPA Act now? If you are able to ask all these questions, and who gives you the right to ask all these questions is the DPDPA Act. That is why we had the Digital Personal Data Protection Act. So I'm going to talk of only personal data. Personal data also has a very unique definition. It is not personal data, it is personally identifiable information. It's PII. So what is personal data? We all understand over the surface, name, address, name, surname, middle name, your Aadhaar card number, your passport number, all those are personal details or personal information above the surface. Below the surface, analytics, RFID, mobile app data, all that is sort of unseen below the surface, all that is also personal information. Because personally identifiable information is a little more, because I also heard about masking and anonymization and pseudonymization, but those are also very tricky words. Because what does the DPDP Act say? That even if you mask, even if you anonymize, but if you are able to point a finger at an individual even after masking, you are not in compliance with law. I'll give you an example. Let's say lawyers in Pune. I'm already, my subset is small. Then all citizens in Pune, and then I say lawyers in Pune. Then I say women lawyers in Pune. We have a smaller subset. Women lawyers in Pune who have studied from a certain, I'm not even taking a name. Women lawyers in Pune who have studied from a certain college. Women lawyers in Pune who have studied in a certain college and practice cyber law. Maybe 5. And now even if you have not, even with this, you are able to say, okay, she must have been that person. So where's your masking, where is your anonymization, where is your pseudonymization? So this is also very important when we look at how you want to deal with personal information and when you have to look at what is called as compliance, because it's been very well worded in the legislation. I'll talk about 2 more concepts. Because I always feel, when we talk of DPDPA Act, somehow it's made so complex sometimes. Just look at these 2 very beautiful words, data principal and data fiduciary. The moment you use the word fiduciary, everything is included. It means it's a relationship of trust. And the moment you say a relationship of trust, leave alone DPDP Act, even in normal conventional law, there is a duty that gets imposed on a person who has been entrusted with property. I leave my phone over there and say, sir, please watch it till I give my lecture or till I speak to the audience. So there is a unsaid contract that that person can't walk away with my phone. Right? It has been just entrusted to look after the phone while I'm on stage. There no additional rights have been given. He can't open it, he can't look through my messages, he can't walk away with the phone, he just has to watch it. Simple definition of a fiduciary. So what is, when you say a data fiduciary, that is what is required to be done by businesses who get hold of personally identifiable information. If I have to give a parallel, because it's very easy to understand that, what banks do. I entrust my money with the bank for a purpose that the bank will keep. So I trust the bank that the bank will keep it safe. It will use it only for the intended purpose, that whenever I want it, I should be able to withdraw it. The bank can't say, oh, we gave it all away in loans. Now I can't give the money which was in your save. Can't do that, right? So I believe that the bank will keep my money as it is. They will do their business definitely. I will earn interest at a certain rate, and at whatever time I want, I should be able to withdraw the money in the same form. The bank cannot change the form of the money. The bank cannot say, on our own, we have put them into mutual funds. Because we've started a new business, so we thought, let's put your money there. No, they can't do that. All that because it is a relationship of trust. Of course, governed by Banking Regulation Act and all other regulations. So the moment the legislators in their wisdom thought, let us use this word, all of this came in. That the moment a data principal, and he has been put at a higher footing, that he is the owner of the data. The person who is giving information, personally identifiable information to a business is the owner of the data, entrusting the data in the fiduciary, and hence the fiduciary has certain obligations over the personally identifiable information. Quickly, let's talk of, let's say, 5 obligations. The first is purpose limitation. So if you need to look at what the privacy principles are, use the data for what it has been given. That's the purpose limitation. So if the data has been given for delivering whatever object I have bought to my address, just use the data for that and for no other purpose. Second is consent and legitimate use. I speak to a lot of clients and they say, oh, it's so easy, we'll take consent for everything. No, that's not what the law is expecting you to do, because there is consent fatigue there. And anyway, then everybody is going to say yes or no without really understanding what that is. So you need not take consent for everything, because if it is for legitimate purpose, that you cannot give service if you don't have that data, even in the absence of consent, you can process the data. Again, an example, let's say any e-commerce site where the object needs to be delivered to your residence. If you don't give your residential address, the service cannot be given. So irrespective of consent, that is not necessary. Even in the absence of consent, if the address has been taken, that can be processed for the purpose of delivery of the object to that address. So I talked of purpose limitation, I talked of legitimate use and consent, which are two completely different concepts. Sometimes there are overlaps. Data minimization. It's not, chalo rakh lete hain. No, you no longer can do that. Just take just enough that you need to give the service or the product, only that much. I had one conversation with the client once, and we were discussing about why do you need the title. So it's in a form, you have MS, Mr., Mrs., and then the name. So I asked them, why do you need the title? In terms of a data minimization discussion, do you really need it? Sometimes you do, because you have to give maybe some benefits after the death of the spouse, or maternity benefits. So sometimes you may need the gender. You may not need the marital status. So this is, for every data point, you need to ask these questions, is it really necessary? And the most wonderful part of this legislation is, there is no rule book. Till now, rules will come out, but even then, there will be, the rules are not going to be very prescriptive. Do A, B, C, D up to F, and then you are compliant. Compliance has to be demonstrated. Compliance has to be demonstrable. You should be able to explain the compliance, and then you are free to do what you want. I'll give you again another incident in one of the cases which happened. So cybersecurity controls, the IT Act said that the bare minimum control you can have is 27,001 compliance. So we were having one case, and we put one branch manager in the witness box. It was about demonstrating that the bank was compliant in terms of 27,001 in terms of cybersecurity. And we started asking very simple questions in the cross-examination. What is the software that you use to process the numbers? And what kind of cybersecurity controls? Name 5 cybersecurity controls that are mentioned in the 27,001 standard. And it was not possible for that person to explain, and we won the case. So it was as simple as that. The certificate was filed. A standard compliance and an audit report was filed, but if the person in charge is unable to demonstrate, and why am I saying this? Because these are practical scenarios when it even comes to demonstrating privacy compliance. So you can talk of 10 and 100 things that are getting deployed within the company, but if the demonstration is not there, then it will be very difficult. Let me just touch upon last 2 topics. AI governance was covered, AI governance, but the earlier panel covered AI governance in a wonderful way, so I'm not going to be there. I don't have enough time also. 2 more principles that we need to remember is data retention. Even when I speak to a lot of my clients, one is they don't even know how much. So data visibility is one very basic principle that we need to follow when we talk of impact assessments. And second is retention. Where is it stored and how long is it stored? Most of the time we get answers, oh, it's stored forever. Why? We don't know. Does the law ask you to store it forever? No, because every sectoral legislation will also ask you to store it for a fixed number of years, and then it has to be deleted unless there is a court hold on it. So if there is any dispute, ongoing dispute, then you may not destroy the data. So data retention is something that you need to be very careful about, and confidentiality. Data breach notification laws are getting stricter and more stringent day by day, and protection of the personal information that you have in your custody is now of paramount importance. So when we talk of data privacy, cybersecurity is part and parcel of the protection of the data that is under your control. And any breach, when I started, I said the lawyers come in the last because that's the first call we get when there is a breach incident. Or there's a ransomware attack. But sometimes we feel if we had known about all this earlier, then we could have prevented the ransomware attack, or we could have prevented the breach that we are talking about, and what is needed to be done after the breach incident. So that is something that we all need to be very careful about. Last but not the least, let me just talk about data privacy and AI, because this has been the hot topic through the day. And let me talk of just 3 risks there. The first risk is a bias that creeps in. Somebody also talked about the quality of data, and there are 2 kinds of biases. One is the bias in the quality of that creeps in because of the quality of the data, and the second bias creeps in because the algorithm. So we need to watch out on both. We don't have the regulation in place yet, but the EU AI Act has come in, and with very, very strict, very prescriptive guidelines, which actually the law shouldn't be like that. We say a law always has to be a living instrument. The second is, when we talk of, first was the bias, second is lack of adequate AI governance standards. We don't have AI governance standards in India at least, and the lack of awareness of applicable laws is the third risk that we face when we talk of data privacy and AI together. I think I've just finished on time. I know we're all waiting for our dinner. Thank you very much for patient listening.